Hello, everyone. Thank you for joining our webinar today. I will get us started as usual by going over the agenda. In a few moments, I will turn the program over to one of my colleagues in our Rochester office, Kristen Lowe. Kristen is going to provide us with a refresher on the rules surrounding volunteers and interns. And next, we will have Devin Karras from our New York City office. Devin will be discussing the suspended enforcement of a significant health plan rule. And last but certainly not least, Andrew Del Zotto is with us from our Westchester office. Andrew will be updating us on recent court decisions, finding the Department of Education's anti-DEI Dear Colleague letter unlawful. Okay, I will now turn the program over to Kristen for her update. Kristen?
Good afternoon, everybody. Thank you. We wanted to touch base with you a little bit about volunteers and interns because it sort of seems like 'tis the season. Students are home from college, the weather is nice, new graduates, and you may be thinking about volunteer opportunities, or you may be getting requests about internship possibilities. So there are actually some pretty specific and stringent rules with respect to those opportunities, and we wanted to make sure they are on your mind as you're looking at these possibilities. So for volunteers, we'll start there. Someone can perform volunteer work in a not-for-profit if the organization is set up for the purposes that you see there on your slide. So again, we're focusing here on not-for-profit institutions. Even if you are a not-for-profit, there are restrictions that are going to apply to the activities that you can have your intern, or rather your volunteers performing. For example, they can't replace or augment your paid staff members, and they really can't perform tasks other than those traditionally reserved for volunteers. In terms of the conditions in which you can bring volunteers on board, they can't be required to perform duties involuntarily. They can't be under any contract to hire. And of course, they can't be paid for their services. There is a possibility that you can provide them with reimbursement, which would not constitute pay, raising a concern under the wage and hour requirements. But those are just some things to keep in mind. Students who are working in a volunteer capacity for a not-for-profit are exempt from the minimum wage and minimum wage order requirements, only if certain factors are met. And again, we do encourage you to check in with your bond attorney because the factors are pretty significant. For example, you've got, again, the organization meets the requirements for a not-for-profit. The student must attend an institution of learning with courses leading to a degree, or they may be completing some residency requirements required for certain academic programs. When you're looking at this, there are also some documentation requirements that you want to be aware of. For example, if you have a student who you're looking to bring on as a volunteer and meet these exemption requirements, you need to get a statement from their school attesting to their student status. So that's just an overview. We don't have the time to go into all of the factors, but these are some of the initial things that you want to be thinking about in terms of not-for-profit opportunities for volunteers and student interns. We can go to the next slide. I'll get into a little more information about internship opportunities. So generally speaking, an intern is only going to be exempt from minimum wage and overtime requirements if they are not in an employment relationship. And the determination about the existence of an employment relationship involves 11 factors. So no shortage of things to consider and document when you are considering bringing someone on for an internship, paid or unpaid. In some situations where we are looking at requirements or making a determination, it's a balancing test. Here, all 11 of the factors have to be met in order to satisfy the exemption. And you'll see here that the factors, some of them come from the federal requirements, and then New York State tacks on our own because Because who doesn't want to look at an 11-factor test to determine whether an internship is exempt from minimum wage and overtime requirements? So we don't have time to go through all of the factors, but again, I just want to give you some things to think about. If you have an internship program, if you're looking to commence an internship program, or if you've received an inquiry about it. The training, even though it includes actual operation of your facilities, must be similar to the training that the intern would receive in an educational program. So that's the first thing. It needs to build upon the academic experience in the classroom, not build upon your operations as the employer. That's factor one. Factor two deals with the primary beneficiary test. And that test comes from a 2015 Second Circuit case called Fox Searchlight. And basically the training or the internship has to primarily benefit the intern or the student and not the employer. If the, and this is something to pay attention to, if the academic institution that they attend gives credit for the internship, that's something that is considered to be evidence of the student intern receiving the primary benefit of the internship opportunity. So that's good to know. Factor number three, the intern can't displace regular employees and they must work under close supervision. So sometimes, and I think that this is another way to help kind of frame your thinking about internship opportunities. In most circumstances, they're going to require more work on the part of the employer than not. And again, that sort of harkens back to that primary beneficiary test. You're going to need to spend time supervising interns. You're going to provide hopefully some training, which is going to, again, take more time and resources. And the operation of the internship program may actually detract from some of the productivity of your normal operations. That's, something you want to give some thought to if you are looking to establish or maintain an internship program that is compliant and qualifies for the exemption under minimum wage and minimum wage order requirements. And the last thing that I'll talk about in terms of the factors to consider is just the documentation that's required. You want to make sure you have these factors and the analysis that you did in writing, and make sure the student and the intern is clear on these factors and clear on the nature of the relationship prior to the start of the internship. So Carrie, I think that's all I have for overview.
Great, thank you, Kristen. So just one question for you, and I think you alluded to it a little bit when you were talking about the documentation, but let's say an employer's reviewed all of the factors that you just went over from New York State and Federal Department of Labor and feels pretty confident that the internship program qualifies as exempt. Is there anything they should be doing to help bolster the fact that, they think this program qualifies?
Yes, I think, in addition to the normal record keeping requirements, it is very helpful to have some sort of agreement in writing, a template that you use to document these relationships, to confirm that there is no expectation of pay, that it is an internship, that it is not an employment relationship, and to, describe the nature of the duties that the individual will be performing, observing, engaging in, the training that they will be participating in. It's not determinative to establish an internship versus an employment relationship, but it's definitely something that's helpful if there was ever a question raised that you could pull out and review.
Thank you. Yeah, that's very helpful. Okay, great. Thanks a lot, Kristen. Next, we have Devin, who's going to discuss the health plan rule and the suspended enforcement. Devin, thanks for joining us today. I will now turn it over to you.
Sure. Hi, everyone. Thanks. Again, this is Devin Karras here with Bonds Employee Benefits and Executive Compensation Practice Group. Sort of out of the gate, if there's any topic that anyone in attendance would like me or any of my employee benefits colleagues to cover at one of these Tuesday presentations, feel free to reach out and let me know. My contact information is listed here. That's employee benefit stuff can be complicated, and we're here to help and discuss things on these Tuesday webinars. So I just wanted to get that sort of housekeeping thing out the way. So, yeah, that said, a lot of insurers and health plan sponsors are breathing a sigh of relief because around mid-May last month, the Departments of Labor, Health and Human Services, and the Treasury Departments announced that, at least for the foreseeable future, the federal government's not going to be enforcing final regulations that were issued in September of 2024 that were intended to refine and kind of clarify requirements under the Mental Health Parity and Addiction Equity Act. Acronym is MAPEA. So, as background, because a lot of this is, some context is important here. MAPEA generally requires health insurance plans and issuers to provide mental health and substance abuse disorder benefits on a comparable basis with medical and surgical benefits. It's a laudable goal. It's good legislation, but sort of enacting it and fine tuning it has become a very tough road to hoe for a lot of plan sponsors and health insurance issuers, because getting from this goal of providing comparable coverage for health and substance use disorder benefits versus your sort of traditional medical and surgical benefits, it's been sort of unclear how to get there. So, to help clarify that, in 2013, there were some preliminary initial final regulations regarding what's called quantitative and non-quantitative treatment limitations. So non-quantitative treatment limitations, or the acronym in our space is NQTLs, they're meant to ensure that individuals and group health plans who seek treatment for covered mental health or substance use disorder care don't face greater burdens on access to those treatments for mental health or substance use disorder care than they would face when seeking coverage for more traditional medical and surgical care. They want to make sure that there's parity among your mental health benefits and your medical surgical benefits, so that the barriers to care are not more onerous for those seeking mental health or substance use disorder treatments. So, an NQTL, or a non-quantitative treatment limitation, the best way to describe an NQTL is like it's sort of like a prior authorization, a required referral, a step therapy protocol, or a utilization review that the plan requires covered individuals to meet before care can be provided. So, that's sort of an example of what an NQTL is. And it's essentially, it can be argued it's a cost-saving mechanism, or otherwise sort of like a barrier to care before the expensive benefits kick in. So, to essentially clarify this NQTL parity requirement, additional rules were passed under the Consolidated Appropriations Act of 2021 that required plans and insurers to perform and document a comparative analysis that would show that NQTLs for medical surgical treatment and mental health and substance abuse disorder treatments are comparable. And this comparative analysis needed to be under the Consolidated Appropriations Act, CAA, needs to be documented to show, okay, so the NQTLs for medical surgical are the same as they are for mental health and substance abuse disorder treatments. It was, however, the 2021 CAA statutory requirement was not at all fleshed out as is common with legislation, and they deferred to the Departments of Health and Human Services, Department of Labor, and Treasury to sort of flesh out how these comparative analyses are to be undertaken. So nothing was really clarified until late last year, around September, when these three agencies jointly issued their final regulations. And they were kind of complicated, and they didn't leave a lot of time for plan sponsors and insurers to sort of get the ball rolling and to digest them. They're effective at the beginning of this year. The argument was that plan sponsors, since the 2021 CAA Act was passed, should have at least been operating in good faith. And the idea was that, at least from the federal perspective, was that it wouldn't be too difficult to comply with these NQTL required comparative analysis. So turns out that the final regulations were cumbersome, difficult to sort of digest and understand, and they the goal, as I said, was to clarify and flesh out the requirements for these NQTL comparative analyses that were passed in 2021. But so they added all these requirements to make sure that the NQTL comparative analysis was sufficient. So there was like a data evaluation requirement. There's design and application requirements. These are all specific requirements identified and clarified in the 2024 final regs to make things more concrete when agencies and plan beneficiaries would be looking and comparing their NQTLs from mental health and substance use disorder benefits and comparing those NQTLs with the NQTLs that would apply for medical and surgical benefits. It turns out as I said, these requirements are very cumbersome, and I'm just going to, as I said, I'm going to go through a couple of them here. It's not exhaustive, but so there's these relevant data requirement that was a very granular detail had to be included as part of this comparative analysis. That if a review of the relevant data would suggest a material difference in access to mental health or substance use disorder benefits based on an NQTL, and if a material difference in access to that benefit is greater than access to medical surgical care, the plan would have to be revised, and the NQTL would have to be ratcheted down to make access to mental health substance use disorder benefit more easily available. In addition, there were at least six content requirements that need to be included as part of a planner issuer's NQTL comparative analysis. Again, they were very kind of complicated and detailed. There's also a plan fiduciary certification requirement where plan sponsors would have to certify in writing that they use the prudent process to select service providers to conduct these NQTL comparative analysis. There was really no clear way on how this was supposed to be done. There was also, in the final regs issued late last year, there was a DOL, HHS audit steps that would be taken. So any of those agencies could come to a health plan sponsor or insurer and demand within 10 days a copy of the comparative analysis. And failure to provide that comparative analysis could result in penalties or other adverse consequences for the plan sponsor, including having to cover people without the NQTLs in place, which would be costly for the carrier or the insurer. As I said earlier, this is very kind of cumbersome and unclear guidance. So earlier this year in January, the ERISA Industry Committee, acronym ERIC, filed suit in federal court arguing that the final rule is arbitrary and capricious and contrary to law. In light of the ERIC lawsuit, which I think, there was a lot of support among plan sponsors and insurers, because again, they were just feeling very kind of lost on how to implement these rules and carry out these NQTL comparative analyses. The current administration, as I said, in May, asked that the ERIC litigation be held in abeyance while the departments are going to be considering the final rule that was issued in 2024 and potentially modifying, rescinding, or amending it, or just terminating the rule completely. Any of these modifications are going to be subject to review and comment by the public pursuant to the regular notice and comment period for any regulation. So you may or may not be aware, this can be very time consuming. So essentially, in their guidance that was issued in early last month, or late last month rather, May 15th, the departments indicated that the final rule, once it is finalized, won't be effective until 18 months after the final ruling in the ERIC, in the litigation that was just issued or commenced earlier in the year. So long story short, there's going to be non-enforcement action. So plan sponsors are not going to be required to comply with the NQTL requirement in accordance with the final regulation for quite some time. There's a reprieve with respect to undertaking these comparative analysis for the indefinite future, which is a very good thing. However, the statutory requirement, the NQTL comparative analysis, still has to be undertaken theoretically, because that's a statutory requirement. However, the NQTL comparative analysis does not have to be undertaken in accordance with the final regs. So At this point, we're advising clients to take their best steps and make a good faith effort to work with their carriers or engage with a third-party administrator or outside service provider to assist them with their NQTL compliance requirements. But again, the rigor of those requirements is a lot less now because those 2024 final rules were suspended. So as I said, you want to make sure that you take good faith efforts to comply with the comparative analysis requirements, but the guidance of the 2024 regs is not there for, is really not applicable at the moment. The agencies indicated that they're going to be providing updates every 90 days. So essentially watch this space for any updates that we might be providing everybody. There's also an article on the bond website that provides a written summary of this, what I'm going over now. So long story short, hopefully some of you are breathing a sigh of relief, but we're not completely out of the woods yet. It's just that the real confusing and ambiguous requirements for the 2024 regs don't seem to be applying indefinitely. So that's basically it. And hopefully it's good news all around.
Thanks, Devin. We
Sure.
appreciate the update. And as Devin mentioned, if you're looking for a good overview of this topic, you can access the client alert on our firm's website. So please do that. I will now turn things over to Andrew, who will discuss the court decisions finding the Department of Education's anti-DEI Dear Colleague letter unlawful. Andrew?
Great. Thanks, Carrie. Good afternoon, everyone. Thanks for joining us for another Tuesday webinar. My name is Andrew Delzato, and I'm associate in the Bonds Labor Department and based out of the Westchester office. Today, I'm here to update everyone on a series of recent federal court decisions that have affected the Trump administration's ability to enforce its executive order that seeks to crack down on DEI programs, policies, and initiatives in the education space specifically. To start off, you can flip to the next slide, Sophie. To start, you'll see here on the screen is a basic timeline of a few of the important things that have happened since President Trump took office in January. And if you go on to the next slide, I'm sure many of you will recall that in the first wave of his executive orders, there was one entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. This one got a decent amount of media coverage at the time, but it really wasn't until mid-February that the new Trump DOE turned up the temperature and began signaling that enforcement was sort of imminent for institutions that didn't fall into line. Next slide, please. So this signal was in the form of a Dear Colleague letter, which is pretty standard. This was sent out to educational institutions, K-12 and post-secondary. In a nutshell, this DCL asserted that many of the educational institutions have, quote, embraced pervasive and repugnant race-based preferences and other forms of racial discrimination in every facet of their operations, and have toxically indoctrinated students with the false premise that the United States is built upon systemic and structural racism and advanced discriminatory policies and practices under the banner of DEI. So this letter makes it clear that institutions that continue to advance quote unquote illegal DEI, which ironically isn't really defined in the letter or the executive order, will jeopardize their receipt of federal funding, which includes federal financial aid. Immediately after this letter was circulated around, education institutions rightfully began asking questions about how to operate moving forward in light of this. While the answers to these questions are sort of still in an evolution process, unsurprisingly, one of the responses was to challenge the executive order in the letter altogether. So that's exactly what happened around the middle of March. And by the end of April, 2 U.S. district courts issued orders narrowly restricting the DOE's enforcement of both the executive order and the letter. So if you flip to the next slide, we can flesh out both of those. So the first one was brought in March in the U.S. District Court for the District of New Hampshire by a series of plaintiffs, including the National Education Association and the American Civil Liberties Union, the ACLU. In this order, the court found that plaintiffs had shown that the DCL was so vague that it denied due process, suppressed legitimate speech, in violation of the First Amendment and violated the Administrative Procedure Act by not following the notice and comment process for rulemaking, which can take months, if not years. The result of this was the court finding sufficient evidence to grant a preliminary injunction. And so while this sort of looks like a great win for all institutions on paper, the scope of this particular injunction only applies to enforcement actions against, and quoting from the court here, plaintiffs, their members, and any entity that employs, contracts with, or works with one or more of the plaintiffs or the plaintiffs' members. So essentially, unless your institution touches these plaintiffs in some way in this particular New Hampshire focused case, this particular injunction doesn't really apply to your institution. However, as people have sort of, predicted before all this would happen, the first one of these injunctions could and probably will, serve as the template for future ones. So the narrow scope of this injunction is because the court noted that nationwide injunctions, particularly nationwide preliminary injunctions, have recently received sharp criticism, including from the U.S. Supreme Court. While this order does not prevent the DOE from enforcing the letter or the executive order upon any institution or entity outside of this limited scope, limited to essentially, institutions that are touching these plaintiffs in this particular case. Again, it's going to serve as the template for similar orders across the country. And in the middle of May, the parties in this case agreed to a briefing schedule regarding competing motions to dismiss. So assuming that it's adopted, the motions to dismiss will be fully briefed by the end of July of this year. So hopefully there will be some more updates then. If you flip to the next slide, on the very same day as this New Hampshire decision, the U.S. District Court for the District of Maryland issues what's called a temporary stay in a substantively similar case brought by the American Federation of Teachers and its Maryland specific affiliate. This temporary stay is going to prevent the DOE from enforcing some of the provisions of the letter, and it's implementing FAQs that go beyond existing law so as to, quote, preserve the status or rights pending conclusion of the review proceedings without precluding the DOE from enforcing any policies within its existing legal authority. So while the Maryland court's temporary stay is broader than the New Hampshire court's injunction in that it applies nationwide theoretically, it also recognizes that during the litigation, the DOE may undertake enforcement actions in accordance with existing law that had already, been on the books before all this action. So as with the New Hampshire case, the parties in this Maryland action recently agreed to a briefing schedule, and that was adopted by the court. So motions are scheduled to be fully briefed by the end of July as well. So hopefully, in about a month, we'll have a better idea of, the procedural posture and where these cases are ultimately going. If you flip to the last slide, while these grants of temporary relief are certainly a setback for the DOE, which has not appealed these decisions as of today, it will certainly continue to enforce its agenda wherever it can, as I'm sure you'd imagine. So even if the courts ultimately strike down most or all of the letter and its implementation, the DOE could move to clarify the regulations via the typical notice and comment and rulemaking procedure, which again could take months or even years to complete. So all of this means the path forward in this area is still really uncertain, which makes consultation with legal counsel, of course, to assess the impact of these developments on your particular institution all the more important. And of course, luckily for you, bond attorneys are following these legal developments closely. A lot of these issues are very fact specific. So we're here to help you navigate you and your institutions through it all. So thanks again for tuning in, and don't hesitate to reach out with any questions you have.
Thanks, Andrew. We appreciate your update. That's very helpful. And thank you everyone for tuning into the webinar today. We have the contact information for you for all of today's presenters on the screen right now. Please feel free to contact any of the presenters or myself if you have any questions. Gabe will be hosting the webinar next week on June 10th, so please join him if you're able to do so. Have a great rest of your day. Thanks so much.